evening, ladies and gentlemen, brothers and sisters. Welcome to the Truth Table. This is episode 88. And tonight's show is about Niagara Regional workers who were working remotely from home. And their company in September 2021, September 7th, I believe, 2021, were pressured and coerced into getting the thing. And being that they're remote workers, they were working from home. It really didn't make any sense and it wasn't really justified. So this show is going back a few years, but it is addressing what happened to them and perhaps some solution and some remedies. We're not here to give legal advice, me and my friend Chris. Um, we may quote some sections of law, but that isn't legal advice. It's just showing exactly what the law says. And I just wanted to make that clear up front. And I'd like to welcome a good friend and a guest multiple times on the Truth Table, Chris Weisdorf. Thank you for coming again.
Thank you. Thank you for having me, Paul.
Also, we have our victims, I will call them, because to me they are victims. We have Jane and Eli. Thank you both for coming as well. And if you have any questions, please feel free to ask. I'll hand it over to Chris so he can address what he has read in the of statement of
The statement of claim.
statement of claim. Thanks.
So I don't have all the information here very clearly. I have a statement of claim. I have an amendment statement of claim. Then it looks like, well, there was this motion that was brought. It says here, like it says, this motion is granted in part in the portion of the claim related to the plaintiff's assertion of the tort of malfeasance in public office is struck. So right there, I don't see it. That's not in any of the materials. This tort of malfeasance, like misfeasance of public office, it basically means that someone in the government acted kind of untowards and tried to harm the litigants. So, and I've seen that pled before in other cases, but it hasn't succeeded thus far. And there are strict standards regarding that. So it was brought up, substantially in a 2003 case involving someone who died, and it was from police conduct. So there's a definitely, it's a high bar, you know. And what I have here is it mentions that is struck, even though I don't see it in either of the statements of claim, the first one or the amended one. Then the second order says, in connection with the claim's assertion of the tort of misfeasance in public office, the plaintiffs are granted leave to amend the claim to identify additional proposed representative plaintiffs and to plead material facts in relation to claims by such plaintiffs who are not afforded grievance rights by the FP SLR SLRA. It's the governing legislation for union workers. I believe that's federal too. I mean, I haven't looked at that in a while, but it's a labor relations regime. I believe it's the federal labor relations regime. So, and it says the motion is otherwise dismissed, no costs are awarded. So this is done. This was brought in 2023, and in 2025, in January, this motion, I guess it was a motion to strike, and I haven't seen any of the materials. I'm just looking at this decision. There's not a lot here. So this is what I see. So what I can do is go over the amended statement of claim, at least, because there's the original one and the amended one. They're not substantially different. I can go over that and explain what was argued. In terms of this decision, it just means that they can move forward. They just need to amend the statement of claim. And none of the charter stuff is addressed here. I'll explain all that about what was pleaded in the statement of claim. So so I'm just going to go over this, and to be clear again, I'm not a legal professional, so I'm not a lawyer, I'm not a paralegal. I did win the Fernando appeal, which is a Quarantine Act appeal, the only one won in Canada, and it was won last year at the end of June, really made public in about 2 weeks later in July. So I won that, and then I also helped Cullen McDonald with his appeal, and that was regarding, it was protesting rights, simple protesting rights. They wanted to criminalize the protesting rights. They literally did criminalize it, and they said literally in their documents, the prosecution said that what he did was the equivalent, by simply holding protests, was the equivalent of knowingly spreading HIV. They literally said protesting during COVID is no different than spreading HIV, because he was charged with common nuisance under the criminal code. So Cullen won that. It was a double appeal. It was the decision was rendered in court, which never, ever, ever, ever happens. And then the reasons were delivered 2 hours later, which never, 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 never happens, let alone on a double appeal. It just doesn't happen. It doesn't happen. And those decisions have not been made public. They were not put up on Canley, and the decision was otherwise just, it was in the actual email. It said it's confidential. So anyway, I'm glad for that, because I thought the decision was just, I totally disagreed with it. But at the end of the day, it agreed with the prosecution and everything. Last two paragraphs. Oh, but at the same time, we can't uphold any kind of convictions. So anyway, with respect to me looking at this, that's through my lens is a lens where I have not gone to law school, and I won the Fernando appeal. I was able to represent Melanie Fernando, the appellant in that case. I was not able to represent Cullen. And Cullen he wasn't even allowed to argue his case. Like all the written submissions were submitted, and the judge said, no, I don't need to hear anything. So I didn't get to say anything. He didn't get to say anything, and he won. Anyway, because I would have had a whole lot to say regarding, it got about a half an hour to make the arguments, but I would have had a whole lot to say about how none of this stuff is in the regulatory regime during COVID, in the provincial regulatory regime. Arrest powers are not in there. They arrested him and charged him under the criminal code. You're not allowed to do that. You have to bring an injunction. If you bring the injunction, then you have the power of arrest. You don't do that, and they did that with Adam Skelly's case, and that's the case that I'm intimately involved in, is Adam Skelly's case. Working with counsel, 6 experts. That case it's been going on for 4.5 years. People think it's dead. It's not. So in that case, they did bring an injunction, and then they still charged him criminally. It's a pile of garbage. So it's a real mess. So that's a very interesting case with respect to legal powers, what the government can and can't do. So in this case is like so many others. This Neprali case is like so many others. And what's different about this case is how the motion to strike was not successful. In every other case, the motion in every other union-related case, the motion to strike was successful. So I'm going to read through this for everyone. Yep. I'm not going to read everything. I'm just going to summarize stuff, because I've looked at this and I know the structure of the claim. So
we covered Cullen, and this is based on the same event, the same emergency.
Yeah, it's Niagara. Yeah. Well, the difference between Cullen and this is Cullen was protesting, and that was 2021 I think it was April.
And these people are at home, remote working at home.
Yeah, that's true, and that speaks to how irrational everything was, and how no courts wanted to listen to the terms arbitrary and irrational. Eventually, these terms were brought up a lot in a book written by the I think it was written by the executive director and litigation director of the Canadian Constitution Foundation. and they use the terms arbitrary and irrational a lot. But this book came out, I think it only came out last year, at the beginning of last year. I think so. So it was well after the fact, but they said the right things, and unfortunately wasn't argued at the time. No one really argued this stuff at the time, and certainly no one argued it with proper scientific evidence. It's the only way to challenge a lie, a scientific lie, is to use scientific truth. And no one wants to do that. They're like, "Oh, don't do it. It's not worth it. They'll never listen to you." That's nonsense. If that were true, um, well, unfortunately, it hasn't. Nothing has been argued. I was going to say if that were true, I wouldn't have won in court, but I didn't. I didn't argue any of that stuff. I argued on pure legal basis. But in this case, it's the opposite. It's a pure evidentiary basis, right? The legal stuff doesn't matter that much. What matters is what the law says, certainly, but the evidence, the preponderance of the evidence, the balance of probabilities, the scales are tipped pretty heavily by the scientific evidence, if properly brought by experts in a proceeding. No one's bothered doing that with COVID. No one's bothered doing that with climate change. No one's bothered doing that with any scientific lies. And if you look at the history of scientific and medical lies, fraud, or they just didn't want to look at it. They just were either willfully blind or they were just biased or racist or whatever. I mean, for real, we're talking about vitamin C. That's 250 years ago. And they refused to recognize it. They didn't know what it was. The substance was only isolated in 1930, around there, but they didn't know what it was. And eventually it took like I'm trying to remember how many years. I think it was like 149 years, I think, and then another 100 years. It was a very long time for it to be recognized as something that could cure scurvy, and that's what built the British Empire to what it became, and why English is so far the most prevalent language in the world. So this stuff about scientific fraud or scientific inaccuracy or medical fraud or medical inaccuracy, it goes back a long time. There's a long history of that, and sometimes it's delivered and sometimes it isn't. But it's based on all sorts of misunderstandings and biases and racism and all sorts of stuff. Because they were in this case, in this country, when they came over, it was Jacques Cartier. They refused to look at what the native population, the Aboriginal population, the First Nations people, they had the cure, and they just said they're a bunch of savages. That really happened. They knew what it was, but the authority didn't want to listen. The French, the British authorities, they didn't want to listen to any of this stuff. So anyway, so this is not new. And in terms of the 20th century, there have been a lot of these things that have happened, right? So and I can name all of them. Like there's Vioxx is probably the most well-known. It's most recent, from 20 years ago. But then there was Rizulin, and that's another drug. There was fen-phen from the 70s. Eventually, in the 90s, they found it caused heart valve damage. There was thalidomide in the 50s, and there's a lot of chemicals. Yep. There's ketone, there's PFOA, there's all the Monsanto stuff. There's so many different things that were done with DDT and so many different things. So and it took a long time to prove this in court. It took in terms of beating DuPont. Regarding PFOA, took 17 years. It was one lawyer, just a single lawyer, who took up the battle, and eventually a class action firm joined him years later. But it took the effort of one man who made the difference. And there's a whole movie about that called Dark Waters. Came out at the end of 2019. It is my favorite legal movie of all time. So I highly recommend everyone watch it. It's easy to understand. It's an absolutely fantastic movie, and that's PFOA. And with respect to Monsanto, it took decades to beat them. I mean, RFK, he beat them, right? But it took decades to get to that point. I mean, they back in the 80s, they were trying this stuff. They didn't get anywhere. So in terms of COVID, same thing. Everyone knows what's going on. We all know what's going on. There's ample evidence. You got to get it into court. And in terms of vaccination, there's the rights. We're not even talking about the damages yet. We're just talking about their rights. And that's why this lawsuit was brought. So the background is a bunch of union members. They were terminated for not, submitting proof of vaccination, not getting vaccinated, proof of vaccination, what did he call it? Attestation.
Identification.
Sorry, yeah. I thought my connection, it was seemed to be cutting out. When I don't see my
No.
face on there, I'm going to stop. So yeah, the vaccination was there. We all know what happened. There were a bunch of policies, a bunch of mandates, and none of these things were actually legal. What was legal, and this hasn't been challenged, and you really can't challenge it now, it's too late, is the vaccination requirements for businesses. So that's back in, it was September 16th to 2021, when they said they're going to, as of September 22nd, you're going to need a certificate of vaccination and ID, which is what I said back in April of 2020. I said COVID stands for Certificate of
Vaccine
Vaccination
identification.
ID. And some people are even saying,
19 is AI.
yes, it's 19. Yes, exactly. Right.
Yeah, it's
So
coded.
then the 19 is AI. Yeah. So anyway, either way, I said it back then, based on ID 2020, the initiative, and it was pretty early April of 2020, and people said this guy is crazy, and it took a year and a half later I was proven right, and they literally came out in the media and said certificate of vaccination and ID. That, I kid you not. And so when all that was going on, there's two different things that happen here. One is on the employment side, and that's what this is all about. And the other one is on the side of just the people being able to go out and do stuff, being able to go out and go shopping, being able to go to a musical performance, go to the gym, to go and what was it, restaurants, stuff like that,
Yeah.
to congregate with people.
Yeah,
And
because viruses,
so
when you're sitting down, viruses don't go that
it makes
low.
no sense.
Only up here.
It's
Yeah, I
it's
know.
it's silly. It never made any sense.
Yeah, none of it.
Unfortunately, no one challenged it. Yeah,
But they started with physics, 9/11. They just, hard science was just thrown out the window.
yeah,
And same with COVID. The flu suddenly disappeared.
that's right. That's a big one because we know how many people get flu per year. We know how many people die, and this is modeled, but it actually is modeled pretty accurately.
Yep.
They know that it's, and I don't want to get into the no virus stuff. Okay, that's a whole other thing. So
Yeah.
I'm just saying, as an example, if you go back to 2009, the swine flu pandemic, it was like around 60,000 people died from that. That's what they said. Or sorry, I'm trying to remember the name. I think it was 61. It was more like 60 million people got it, and I think the amount of people who died was something 50 or 60,000. So it was sort of like a bad, not a horrible flu year, but sort of a bad flu year. It wasn't that serious. They made a much ado about nothing. People died. And again, we know how this stuff is misrepresented, and in terms of PCR tests, they really were not done back then, thankfully, because then it would have been way higher. The number would have been inflated 10 times or 50 times or whatever. So yeah,
Overcycle the tests. They've got the numbers they need.
yeah. Well, that's the whole point about COVID. If you don't have no testing, no media, no masking, no pandemic, right? It's
Yep.
it's pretty obvious. If we didn't have that, if the media is the media, but ultimately, if there was no masking and no testing, and testing is most important for those cases, then there is no pandemic, right? But the masking was there to keep people afraid when the numbers went down. So in terms of what this challenge is about, the employment side. Almost all of the challenges, I would say all of them, from what I recall. I'm trying to remember going back to the end of 2020, beginning of 2021, there were some challenges that went against the lockdowns. And the Ingram challenge in Alberta kind of worked its way up. Eventually, there was all sorts of proceedings from some. She's a gym owner, and so eventually, I believe it was August of 2023, August of 2023, she had the public health order struck. It was a terrible decision because otherwise it was just. But it was great that she got that result. But the rest of the decision is just awful because the legal basis for striking the arguments in the Alberta Bill of Rights and things like that were nonsense. But nevertheless, she still said, but because the tyranny was exhibited by cabinet and not the chief medical officer of health, that it was ultra vires. It was beyond the powers of cabinet to do that. They were not allowed to do that. They were not authorized in law to do that. So it was struck on that basis. And there's a class action lawsuit that was brought, and it was certified at the end of October 2024. That's a huge, huge lawsuit. It's a lockdown lawsuit, class action, the only one that I know of on the continent in Alberta. And of course, Adams' case, the Adam Skelly, Adamson barbecue case, would obviously be influenced by something like that. And yeah, so I want to stop there because I can go into a lot of different elements of COVID and protesting and mention the Randy Hillier case and things like that, which is important for protesting. And that's a Court of Appeal case, and it was unanimous. But in terms of this is separate. This is totally separate. This is based on the policy, on the mandate. So what they did was and I remember all this, and I can explain this to you very simply. On, I believe it was August 17th of 2021, the Chief Medical Officer of Health here in Ontario came up with a directive. It was Directive 6. And this directive was used to impose health standards on people, and specifically in the healthcare profession. It was made under Section 77.7 of the Health Protection and Promotion Act. Every province has some sort of a health act, and that's what it's called here. And it's made under that, and it's a directive. So with you hear the term mandate used, and it's a terrible term. It's a horrible term. A mandate is something that is used for the military. It's used for courts and military. It's not really used for anything else. So basically, you have to consent to it. You have to be in sort of a proceeding where you consent to the proceeding, and then yes, you can be mandated to do something as a result of that proceeding. And so, if you're in the military, yes, you're there to serve, and if you're mandated to do something, you're going to do it. That's how the military works. It's pretty simple. And same thing with a court proceeding. If you go into a court proceeding, we're talking about civil proceeding. We're not talking about criminal. And then there's a mandate made by a court, especially from one court to another. It's called mandamus. It just means mandate. It means a higher court tells a lower court you must do something. So that's not even concerning the litigants themselves. But nevertheless, an order is an order, and you can maybe call it a mandate, and that's fine. But in terms of what happened here, they used the law made by the legislature. This is this Health Protection and Promotion Act, this Health Act, this health statute, right, where it was properly brought into force, and the Chief Medical Officer of Health is named in there, and the medical officers of health are named, and they're all delegated all this authority by the legislature, right? And this is the thing that was used to impose various restrictions back in 2020. And then they came up with they used the Emergency Management and Civil Protection Act and Reopen Ontario Act. They melded the three together. They used the three to cobble together a bunch of things to make people do things. Okay. But the worst was with the mandate with respect to the vaccination, because it says in this Directive 6, it applies only to the healthcare profession, because that's the only sphere of influence that act has, right? That act where they made this directive, and the reason why I mentioned directive, there's directives, regulations, bylaws, and orders. They're not mandates. Directives, regulations, bylaws, and orders. They're it's called subordinate legislation. So they're made underneath an act. That's why it's subordinate. They're made by someone who has the authority to make it. So in this case, it was the chief medical officer of health. There you go. That's it. I'm glad you brought it up so quickly. It's not always easy to find, but this is it. And it says about all this stuff, immediate risk to the health of persons anywhere in Ontario, blah, 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 and all of that. But it talks about how it's really under this section 77.7 only applies to healthcare providers. So they took that, and right away that applied to everyone who works for, it says here, the Public Hospitals Act, the Home Care and Community Services Act, the Local Health System Integration Act, the Ambulance Services within the Ambulance Act, all of that sort of stuff. But keep in mind, it does not apply to anyone else. So the province was like, well, what are we going to do? And they had a majority government. So they could have amended the law and said, you're going to all be vaccinated, no matter what. They could have done that, but they didn't do that. They did it pussyfooted around it. They came up with this, and a week later, they amended a regulation under the Reopening Ontario Act. It's called 36420. They amended, I think it's section 2.1 under Schedule 1, and they amended it, and they said, if you have a business, you have to follow the public health advice. Fine, follow the public health advice. The bottom line is, and it says you have to have a policy, a vaccination policy. Okay, great. But the policy has to comport with the law, right? There has to be compliance with the laws that's written in Ontario. And the laws that's written in Ontario is very powerful. It actually prevents you from having to consent to something without being informed. And this is in something called the Healthcare Consent Act. Okay, this is really simple. The Ontario has had this law since 1996, this Healthcare Consent Act. BC has a weak version, very weak version. Nova Scotia had it, repealed it. No one else has it. So Ontario has it, and it's worded very much like the Nuremberg Code. It took 49 years, and they brought it into Ontario, into law in Ontario, without referencing the Nuremberg Code. It's law in Ontario. It's not law in Texas. People are so happy to go to Texas. In Texas, all these healthcare workers went to court, and the mandates won over. They lost. And that was early with respect to vaccination. That was very early. I think it was June of 2021. So they said the Nuremberg Code doesn't apply to Texas, which it doesn't. The Nuremberg Code is not a treaty. Okay, the Nuremberg Code has no signatories, right? Even though Canada and the US were there, it's not a treaty. Has no force of law. What has force of law is when the legislature looks at something international, or it could be anywhere. It could be in the United States. It could be in the rest of Canada. It's a provincial legislature says, we want that law here. So they just take a bunch of the language and they put it here. And it goes through 2 readings and then 2 debates. And then it goes through a committee, and then it goes through the final reading, and it becomes law. That's in the province. That's how it works. So they made it law. And in there, it defines, and I'm not going to read it to you now, but it's a very, very, very comprehensive and very strict interpretation of informed consent. So no one used this. No one bothered arguing this. It's not in a statement of claim either, saying no one bothered arguing that, right? So this informed consent is in there to protect people in Ontario, and only people in Ontario. It's the best worded law there is in the country, probably in all of North America. And I mean, maybe now there's something in Florida that's taken its place, but at the time, it was the most strictly worded statute in North America regarding informed consent. No one bothered arguing this. I found out about it at the end of 2020, but no one argued it. So when they started doing stuff with respect to shoving stuff up your nose and eventually, putting a needle into your arm, experimental as it is, it's illegal. You can't do it. You're not allowed to do it. The Quarantine Act the case that I won, the appeal, in Section 14 of the Quarantine Act, federal, it says an instrument cannot enter the body. So if it goes into your nose, you violate the law. That's how I won. I argued it. No, a lot of other people argued it. They didn't argue it comprehensively like I did, and I won. No one bothered arguing this healthcare consent act. So in terms of what people were subjected to, it was they were fired because they didn't want to listen to some stupid policy, some mandate, as they said, which wasn't even authorized in law. None of the stuff was legal. To be clear, none of it was legal. Just because the courts say it's passable now, or it's a reasonable exercise of management's rights under the collective bargaining agreement, under the interpretation of the Labor Relations Act, or this FSLRA, or whatever, the labor code. It doesn't matter. They the key question is regarding informed consent, and the courts have ducked that. And maybe now, maybe with challenges like this, maybe it will somehow succeed. So I want to go over the challenge with you because, in particular, as Paul mentioned, that what happened here was these people were at home and they got fired. How can that happen? And it makes no sense. You're at home and they want you to be vaccinated. If you're not vaccinated, you're fired. How does that make any sense? I mean, you could present stuff on the product monograph and things like that, saying it doesn't prevent transmission or contraction of COVID-19 or anything like that. They said it, and how is it that someone on that basis, where the actual manufacturer admitted it, and then what happened was, at the end of the day, people were fired because they didn't attest or take the vaccination, and they were at home. So how can you possibly discipline someone who's at home for not taking a medical intervention? It makes no sense. It's arbitrary and irrational. So
Absolutely.
I don't know. I got to hear what happened here, but I want to go over what I do have. And I read the decision of this motion to strike, which I assume is a motion to strike. I've read that out. It's a very simple decision, but I don't know what was argued, and I don't have anything of the misfeasance of public office. Other than that, the charter stuff seems to be going through, and hopefully they didn't appeal this decision. They just moved through and amended the actual statement of claim and added some good stuff in there. So I'm going to go over the statement of claim, at least the amended one, very quickly, and then um, I guess we can go through some sort of Q&A, but that's what I'm here for. So I'm going to go over this, and I will go over what the law is regarding informed consent, or at least what the law is with respect to since October of 2021. It was in November of 2021 when informed consent was completely upended, and it remains upended. The whole world is still upside down with respect to this stuff. It's completely against what the law has said, what the Supreme Court has said, what the Ontario Court of Appeal has said, what the legislature has said in the Healthcare Consent Act. It's completely illegal. How is this stuff? How is it still standing? I don't know. It's a total house of cards. But so what this so it was an original statement of claim, and then they amended it. The original one was written by someone in Midtown Toronto, and then the second one was written by someone in downtown Toronto. So they're two different law firms. And again, it's for people in Niagara. If I look at the different people who are involved, they're all unionized. That's what it looks like to me. Maybe I could be corrected, and they're not all unionized, but it looks to me in the motion record, it looks like they're all unionized to me. So that's a problem. It has been a big problem until now, where all these have been struck as having no jurisdiction under the labor relations regime. You have to go through grievance first. And it does say they went through grievances. So if you go through a grievance, that should be it. According to how the Supreme Court has interpreted this stuff, it's not fair. It's not right. The unions have taken dues of members and have lobbied the government over many years to exclude union members from going to court, or even unions themselves from going to court. They have to go through the labor relations regime. They have to appear before the labor board or an arbitrator or both, and no court, right? And in New York, blue state New York, they have unions there too. They were allowed to defeat the vaccination regimes, the mandates, New York City mandate and the state mandate in, I guess it was October, November of 2022. They won outright in the New York Supreme Court. 100%, two different cases, two different judges, union members, all of them won outright because they said it doesn't prevent transmission or contraction. So that worked, but you were not allowed to argue that in Ontario. You have to go through a tribunal or you have to go through an arbitrator. A lot of times it's an arbitrator in a grievance. So this stuff wasn't argued properly. It wasn't brought properly before court because you're not allowed to. This, they tried to do it. So we'll see what happens, but I'm going to go through this. So that's the background. So it says, table of contents, the definitions, parties, defendant, impugn policy, jurisdiction of the court, violation of the Municipal Act, and the Constitution Act 1867 that established Canada. The city retaliated against unvaccinated, undisclosed workers, breach of charter rights, aggravated punitive and bad faith damages, and remedies sought. So the first part is it just gives these definitions about employee, partially vaccinated, fully vaccinated, all that stuff, which we know they've tortured the hell out of these definitions. About 14 days from receipt of a vaccine. Only then are you fully vaccinated. So if you die before that, you're considered unvaccinated. For real. I mean, we know this from back then. Just a little reminder. Proof of vaccination is all this stuff about the certificate of vaccination ID, all that. Privacy, informed consent, collective bargaining agreement, human rights exemption, medical exemption. So they have these exemptions. I should stop right there and just say very briefly that right at the very beginning in August of 2021, their onus was reversed on employees. When the threat letters started coming in, I was one of the first people in Canada to see all these threat letters because I was talking to a lot of people about this. And I saw all these threat letters from people working for banks, people working for various hospitals, various hospital networks, people working for airlines, everything. I saw a lot of these different threat letters, and they weren't worded the same, but they worded similarly, and they never mentioned the term consent or anything regarding consent. They simply mentioned ability or disability or exception or accommodation or human rights. So they basically reversed the onus from the employer having to seek the consent of the employee to the employee having to seek an exemption, which is completely illegal. And to this day, I've never heard anyone talk about that except me. No one's ever brought it up. I've never seen it in any kind of legal challenge. Never seen it, not once. But they reversed the onus.
Well, I'm not a lawyer, but would you consider this a potential crime against humanity?
I wouldn't use that term because it hasn't worked so far in the courts. You gotta work your way up to that, right? How you do it in the courts? How you do it in the courts is you establish that there's a civil wrong committed. So you don't start from the criminal portion first. You don't start from the criminal code or whatever, but from a criminal standard, which is beyond a reasonable doubt, where you have to convince a prosecutor and a justice of the peace to take the case. Well, the JP has to hear it. The prosecutor has to try it. They're both getting government paychecks. It's easy to influence them. We know this from Europe, where they went after a prosecutor for daring to prosecute a case. And look what happened to Helen Gruss, right?
Oh,
so it's the same thing. You don't want to go the criminal route, really at all. You want to go through military tribunals in the future because they're going to shred all the documents. So then you won't be able to convict them criminally. This is why they had the Nuremberg Military Tribunal, because the Nazis burned all their documents. A lot of stuff was destroyed in the war too, but they burned a lot of documents so that they wouldn't be impugned, that they couldn't be prosecuted. So a military tribunal lowers the standard of evidence, standard of proof, from beyond a reasonable doubt, which is over 90%, to on the balance of probabilities or preponderance of evidence to over 50%. That's the scales, whether you tip the scales or not. It's a lot easier to prove, and you can only prove when someone's shredded a bunch of documents, burned the evidence. You can really only prove it on the balance of probabilities. That's why when that woman was killed who were refusing to wear a mask in I think it was Mount Sinai or Toronto General Hospital. It was in Toronto. She was killed, and the judge in that case said, this can't go on. the criminal case cannot go on. People were really angry at that judge. Well, the
Mm.
point is that they pointed the camera away so we couldn't see how she died. So there was no reasonable prospect of conviction, not in a criminal standard. On a civil standard, yes. On a military military tribunal standard, which is on the same civil standard, that beyond the it's the balance of probabilities or preponderance of evidence. You can, yes, you can find them. You can establish that the tort, the wrong, the civil action, that was satisfied on the elements. So, but on criminal, good luck. They burn a bunch of evidence. The cameras are destroyed, and everything is destroyed. You can't prove anything on a criminal basis. You just can't, and they know that. So you don't go through the criminal standard, and you don't go in civil court and plead crimes against humanity. This was done. It failed miserably every time. You don't want to do that. You want to establish that certain wrongs were committed, civil wrongs, that,
Yes.
that at the very least there's negligence or negligent misrepresentation,
Yes.
especially with respect to
Yep.
the vaccines, and that
Mm-hmm.
informed consent itself, that's a tort established by the Supreme Court. It's
Mm-hmm.
established by the Court of Appeal. It's in the law in Ontario. You can argue that. That's even outside of the charter, right? The charter arguments
I think we
are,
would
that's
have.
section 7.
I think
That's
we would
outside
have.
of the charter.
Sorry.
Yeah.
I think we would have a case against food. They're changing food. They're using Latin to change the names of the ingredients to hide things and calling them natural. I mean, that's not informed consent in our food supply. That's, I
Yeah.
think that's the
It
kind of
wouldn't work
thing.
there because it's not a medical intervention. The Healthcare Consent Act and informed consent applies to a medical intervention. So
Okay.
that's pretty wide, but it doesn't apply to food. The food is food, and it wouldn't apply to that. There's other stuff for food. There are other regimes for food, but and of course, if you contaminate food and someone dies, there's there's the criminal route, but there's a civil route. There's a civil route too. There's negligence and things like that, or gross negligence even.
Mhm.
And then there's, of course, criminal negligence causing death. But even if you take out the criminal, there's still civil remedies you could seek, which is a lot easier to get. So sorry, I would like to go through this, and I wanted to mention the reverse onus, how they reversed it from seeking your consent to you. All of a sudden, they don't need to seek your consent. You have to seek an exemption from them. You have to beg them for an exemption, for a medical or religious exemption, and that's a pile of garbage. And that's the only thing that has succeeded thus far is religious exemptions. It's worked in the U.S. It's worked in Canada. It worked in the U.S. first before it worked in Canada. Then all
Well,
of a
in this
sudden it
particular
worked
case,
very
it
well.
didn't. Yeah, it didn't work in this case because medical
Well,
exemption was attempted.
yeah,
And it
yeah.
was,
So I want to go over that. It does say medical exemption. It does say Human Rights Code exemption, and that's really about religion. It says faith, religion, and all
yep,
of that.
yep.
And then it mentions the Charter and the Constitution Act 1867. Then it goes over all the plaintiffs. I'm not going to go over any of this stuff. As far as I know, they're all unionized. We'll see if they are or are not. And then it talks about the regional municipality of Niagara region. Okay, and it talks about them and the municipal act. Then it talks about the policy, and the policy again. It stems from Directive 6, and they just because of Directive 6 and that regulation 36420 that they amended on about a week later. I think it was on August 24th, 2021. So it was August 17th. It was Directive 6. August 24th was the amendment to this regulation made under the Reopening Ontario Act, saying you have to follow any employers have to follow the advice of the Chief Medical Officer of Health and establish a vaccination policy. But as I said, the vaccination policy has to be legal to begin with. None of this stuff was legal. So they established this impugned policy, the vaccination policy, September 7, 2021, proof of vaccination, proof of medical reason documented by a physician using medical exemption form, and then all this stuff. Those have not been fully vaccinated. This is on September 20th, 2021. Those are not being fully vaccinated or who do not disclose their vaccination status have not provided a proof of bona fide medical or human rights code exemption under Section 1.1 of this procedure. by September 20th are encouraged to complete an education session, brainwashing session, provided by the region on the benefits of the vaccination will need to adhere to additional infection and prevention control measures as provided herein. So again, there's the Health Protection and Promotion Act. There's this directive that was made under it. There's the Reopening Ontario Act. There's this regulation that was made under it. So there's two regulations. There's a directive and a regulation. And they cobble them together to say, you have to have, as an employer, you have to have this vaccination policy. The policies themselves don't even comport with what the legislature says. They do not, they don't comport with that. So what it says here is in the directive 6, it mentions the proof of vaccination, it mentions testing, it mentions the exemptions, medical or religious, and then it mentions the brainwashing session. And so they put all that in their policies. They said, well, we're authorized in law. And so I'm not going to go over the rest of this stuff, but that's what this is about, really, what I just said, what's in there. And it says the policy in the face of it recognizes that each employee is protected under the Human Rights Code and by extension the Charter. From a practical and legal perspective, the region of Niagara used the policy as a tool to breach the plaintiff's constitutional and charter rights. That's absolutely true. And then it talks about the non-compliance, failure, refusal to adhere to the terms of this procedure may result in discipline up to including dismissal and or other measures as may be reasonably required to address health and safety, which may include leave of absence or adjustment into working arrangements as determined by the region at sole discretion. So it mentions all that, and then it says the inclusion of termination as a punishment was ultra vires. I mentioned that earlier with respect to that the public health orders being struck in Alberta. Ultra vires just simply means in Latin beyond its powers. So ultra vires, beyond its powers, the legal authority of the region of Niagara, and that the provincial mandates and guidelines within the region was legally required to follow, did not include termination of employees. The termination and the manner in which they terminated was never intended, contemplated, or authorized by any legislative regulations or other means. That's true. It's not in Directive 6. It's not in the regulation under the 36420 under the ROA. It's not in there. It just says you have to follow it. That's all it says. It says the firing the plaintiffs without constitutional legal authority is tantamount to an abuse of process and authority by the defendant. 100%. Jurisdiction of the court. This is a huge thing about the collective bargaining agreements. There is no grievance, arbitration, or adjudication procedure provided for in the plaintiff's respective collective bargaining agreements to address violations of the plaintiff's constitutional and charter rights. The problem there is the courts have found thus far that they don't need it, that it's a reasonable exercise of management's rights under the collective bargaining agreement. That's what courts have repeatedly found in this country. It's absolutely atrocious, but that's what they found. They refused to actually weigh any evidence or look at anything. They just said, it's a reasonable exercise, end of. So it says, consequently, no arbitrator, adjudicator, nor board has exclusive jurisdiction over the whether corporation acted ultra vires beyond the powers of the municipality, municipal act, Constitution Act, the charter, any of that stuff. Their factual circumstances, their totality demonstrates that the region of Niagara acted unilaterally outside of the collective bargaining agreement. I agree with all that. It's not worked thus far. So I'm shocked that this case is still alive. The claim raises constitutional issues and all this stuff, and then it specifically names here. The claim raises further constitutional challenges in the failure to accurately apply the directives and mandates of the Chief Medical Officer of Health of Ontario, and the further failure to interpret and apply the provincial guidelines contrary to and in breach of sections 1, 7, and 15 of the Canadian Charter of Rights and Freedoms. And what's glaring here, I can't believe it's not here, is section 2A or 2D of the Charter. 2A is freedom of conscience and religion, and 2D is essentially the collective bargaining rights enshrined in the Charter. It's the freedom of association, and this was argued by one law firm in BC, and that, it's a class action, and I don't, it hasn't been certified yet, but they weren't able to strike it. So this 2D is a big one, that they violated the collective bargaining process by simply imposing the stuff without a vote of the membership. And I think it's a good argument, but it's not here. It's not, there's no Section 2 stuff. Section 2 of the Charter says fundamental freedoms. Section 2A is, freedom of religion and conscience. Section 2B is freedom of opinion, thought, belief, and expression. 2C is freedom of peaceful assembly, and 2D is freedom of association. So I've said this stuff enough times, I know it by heart. So 2A is the one that 2A and 2D are the ones that would reasonably succeed at this stage of the game, because especially with union members, it would 2D. 2D wouldn't work unless you're part of some kind of association. So a union would definitely be that. And there's a lot of very strong protections that the Supreme Court and the courts have created from that Section 2D since the charter was enacted. And 2A is very powerful too, and that there's the Amselman test, which is the whether you truly believe something or not in terms of religious belief. So that's very powerful, and that's been applied very very well. But it took a long time to be argued properly and then applied. It was applied in what I call the Latin Mass case back in, I think it was 2022, the first win for anyone in a labor relations proceeding. So just to tell you that these things are not in the statement of claim. I don't know why. They're things. I mean, if anything, with this motion to strike, where they got leave to amend, they should throw in sections 2A and 2D in there. Very important, because these rights were clearly breached. And in terms of union, 2D is a biggie and really has not been argued. So in a class action, it has been, and they failed to strike it. So you'd be crazy in 2025 to not argue Section 2D. And 2A, definitely. I mean, if people can maybe bring evidence, they can lead evidence, right? You change the claim, put in religious stuff in there, and maybe you get away with it, right? But you got to pass the Amselman test, which is a high bar, but you might be able to. It's worth arguing. So that's, I just wanted to say that sections 1, 7, and 15. 1 is reasonable limits. Section 7 is essentially, you may not, in terms of life, liberty, and security of the person, you may not be deprived unless it's in accordance with the principles of fundamental justice, which is basically it's substantive rights. I mean, it's the right to not just be heard, but to fight it procedurally, to fight it according to all the principles of fundamental justice, which includes it includes informed consent, because it involves bodily autonomy. Like, bodily autonomy is something that's covered under Section 7, so it's very important. And yeah, so that's in there properly. And then Section 15 is equality, equal protection under law, and being also part of someone. It's you have to be defined as sort of a minority group or some kind of group that can be discriminated against. But at the end of the day, that's part of it. The one part is equal protection under the law. The other one is whether you're discriminated against because you're in a particular group of people. So that has not worked very well, because you'd have to say that being unvaccinated is an analogous ground under the Charter under Section 15. There's the most amount of stuff is under, if you look at the case law, if you look at the Constitutional Law of Canada, which is 2 phone book sized volumes, the largest part of the Charter in terms of all the case law is Section 15. If you look at the various moot competitions they have with law students, it's always Section 15 stuff, right? So there's more stuff about Section 15 than anything else. But at the same time, you have to somehow establish that the unvaccinated are a class that we're discriminated against. So it's more probably about equal before and under the law. I would say probably that.
Yeah.
But the problem with that is that has not worked very well. So Section 15 is not great, but there's a lot to work with. There's certainly a lot that lawyers can bill for Section 15. There's a lot of stuff they got to look up, a lot of research. But nevertheless, Section 1, 7, 15, that's all that's in there, not Section 2. So I want to go next and go over the rest of this. They said they acted outside the authority of the Constitution Act and the Charter. And it says, yeah, that this is constitutional and all of that. So anyway, then it mentions collective bargaining agreement and whether they can be fired or not, and sole discretion and all of that sort of stuff. I just want to kind of finish off what I'm saying here. Okay, this is so. There's other stuff about here. Disciplinary action is reasonable under clause 5 of the policy and all that sort of stuff, and forms of punishment meted out. So that's, and greatest pain is suffering and destruction of lives. So there's stuff at the end of this that I liked. But it says, I guess it's paragraph 37 of the claim. This confuses me. It says this court has jurisdiction to grant the plaintiff's lawyer a prayer for relief regarding damages, including punitive damages, special damages, and any damages that this honorable court may deem just in the circumstance pursuant to section 24 subsection 2 of the charter, or any other form of common law or equitable relief. Yes, any other form of common law or equitable relief, that's fine. But they're citing section 24 sub 2 instead of 24 sub 1. And I have this right here to read for everyone. This is confusing to me because I know both of them. And section 24 sub 1 is what has, that's where when there's a breach of the charter rights, you ask for remedy under section 24 sub 1 or 52 sub 1. 52 sub 1 is a declaration of invalidity. 24 sub 1 is something that's appropriate and just in the circumstances. What it specifically says is 24 sub 1, this is enforcement of guaranteed rights and freedoms. 24 sub 1, anyone whose rights or freedoms is guaranteed in charter being infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. That's what they did not claim relief under. They did not. They said 24 sub 2, exclusion of evidence, bringing administration of justice into disrepute. So it says where in proceedings under subsection 1, a court concludes the evidence was obtained in a manner that was infringed or denied any freedoms, rights or freedoms guaranteed by its charter, the evidence shall be excluded if it is established that having regard to circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. Section 24 sub 2 is only used in criminal proceedings. It's not used in a civil proceeding. So this is a glaring error that if the various plaintiffs, the complainants, they have to say change this right away. This has to be amended, and they have to take out 24 sub 2 and put in 24 sub 1. If you do not do this, you cannot obtain a remedy from the court at any point in the future. This is fatal to the whole statement of claim. It's fatal. I can't say that more plainly than that. I don't know how they made this mistake. I mean, there are two different lawyers who drafted this stuff, the first one and then the second one. 24 sub 2 should be nowhere near this. It should be 24 sub 1. Okay, so I don't know why that's in there. It should be you just take out the sub 2 and put sub 1. 24 bracket parenthesis, left parentheses 1, right parentheses. That's it. It has to be done. If it's not done, you can't get you can get a remedy, but it has to be common law or equitable relief. If you don't plead that, you're not going to get it. Where you have to, under charter damages, unless you plead a tort outside of the charter, you have to really seek relief that's appropriate and just. Otherwise, and this is in the U.S. different. There's Section 1983, which is it's not in the Bill of Rights, not in their Constitution. It's not in there, but we have it in our Constitution. Canada is the only country on the planet which has damages in the actual Constitution. No one else has it, and people they just don't want to look at this. But it's critical to understanding we do have something that's amazing, and it really hasn't been used very much, or it hasn't been used properly. In this case, it hasn't been used at all. So that has to be changed. The rest of this, there's not much left here. The violation of Municipal Act and the Constitution Act. So they're basically saying about the municipal institutions of the province, Section 92, subsection 8 of the Constitution that formed Canada in 1867, that the municipalities incorporated in this authority therefore hold delegated provincial powers requiring the region's policies and regulations to the very least adhere to the provincial mandates issued by the province of Ontario. I wouldn't use that weasel word mandates. Say the law made by the legislature, and
Mhm.
the law that was made pursuant to the statutes, the ROA, the EMCPA, the HPPA, these various things, these acts made by the legislature. So, and then there's stuff here about the provincial government is not regulated mandatory vaccination for members of the police services under the Occupational Health and Safety Act. The service has an obligation to take precaution reasonable to protect employees. And of course, they butchered that, all that stuff to impose this stuff. So, so they're just basically saying that this stuff is not, the region of Niagara is therefore put to strict proof to establish which guideline or mandate by the government of Ontario is relied on to exercise the legal authority to terminate the plaintiffs. Because as I said, if Directive 6 was not used, and they're not all healthcare workers, then they're in trouble. Because it's all of Niagara is imposing it. It's not just the Niagara imposing it on healthcare workers, it's everyone. So they legitimately, they don't have it. They don't have the legal authority. That's correct. So, and then it says here, the region of Niagara has no legal authority to act outside the legal parameters set out in the law and mandated by provincial mandates or guidelines. The region of, this is in big bold print, the region of Niagara acted ultra vires beyond its powers. Its divine legal authority when on February 14, 2022, the region punished the plaintiffs by firing the region of Niagara acted ultra vires, the Constitution Act 1867, Section 92, Sub 8, which is municipal institutions, which is, it just says it signs province's exclusive authority regarding those municipal institutions in the province. And the Municipal Act, which states that the region's policies and regulations must be in accordance with provincial mandates. Again, I don't like that term, provincial law, I would say, which include the health directives mandated by the province of Ontario. Then the city retaliated against all these people and fired them. Breach of the plaintiff's charter rights, Section 7. Remember about everyone has the right to life, liberty, and security of the person, the right not to be deprived thereof, except in accordance with the principles of fundamental justice, one of which is in terms of bodily autonomy, informed consent. So it's in there, and that's important to argue. And so that's great if you can get it heard. That's great, because remember, you're arguing this in terms of people who were unionized. And then Section 15 about every individual is equal before and under the law has the right to equal protection and equal benefit of the law without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. But it could be on analogous grounds, which could be in unvaccinated workers or people who decided to, exercise their informed consent. So the plaintiffs claim that the policy enacted by the region violated their protected rights under Section 15 by directly and indirectly discriminating against them. So I told you about that. And then Section 1, something that's, the charter guarantees rights and freedoms set out, subject only to reasonable limits prescribed by law as can be reasonably justified in a free democratic society. Prescribed by law as can be demonstrably justified is all in bold print, because it's not in the law, right? It's not. It was Directive 6, and yes, they could potentially use that to fire people back then, but it cannot be used outside of healthcare. And even inside of healthcare, Directive 6 directly contravened its enabling statute, which is the Health Protection and Promotion Act, which says outright that you may not test someone. It's Section 77.8, subsection 6 of Directive 6. Directive 6 is long gone. You can't challenge it now. It's too late, right? You cannot challenge it now. But anyway, that's it's the bottom line is Directive 6 contravened the authority which allowed it to be created in the first place. Has anyone bothered arguing this? Only me, in terms of ghostwriting someone's challenge, a nurse's challenge. She was completely thrown to the wolves and fired for refusing to test. So, no. And yeah, the rest of it is, in terms of what's actually written in the law. It's not written in the law. They're saying it's not, so therefore it's a total violation of the law. And other than that, at the end here, it says, I should read this because people will really get what this is about. There's all these different, they individually, collectively suffered the following damages: severe and permanent psychological, physical, and emotional trauma, loss of employment opportunities, worsening physical health because of inadequate mental support, threats and assaults, loss of sleep, loss of trust in others, loss of self-confidence, loss of income, loss of opportunity for future income, post-traumatic stress disorder, breakdown in family relationships, loss of home or shelter, inability to enjoy social interactions, reduced educational opportunities for family and or children. So that's really important. That this stuff is, I really haven't seen this really pleaded before. This is really great to just see it there, just plainly pleaded that these are the things that they've affected, that have they been affected. And then there's the remedies sought, and this is the end of it. This is the end of the claim. So the remedies sought are a declaration that the application of the policy to suspend and or terminate unvaccinated employees was unconstitutional infringement of the constitutional rights of the plaintiffs, a declaration that the region of Niagara acted ultra vires, beyond the powers of under the Constitution Act and or Municipal Act and or any mandates or guidelines provided by the province of Ontario. The plaintiffs also seek the following: a declaration of the plaintiffs' charter rights under Section 7 and 15 have been violated by the corporation in manners not justifiable in a free and democratic society. Damages for violation of the plaintiffs' rights pursuant to Section 7 and 15 of the charter in amount of $300,000 per plaintiff. Punitive and exemplary damages in the amount of $300,000 per plaintiff in breach of the constitutional rights and all of that for retaliation, and such further and other relief this court may decide is provided under Section 24 sub 2 of the Charter of Rights. This is really problematic. Okay, this can kill the whole case. This has to be changed because number one, paragraphs 53 and 54 are fine. The application of policy was an unconstitutional infringement, constitutional rights, great. They acted beyond their powers, great. But also seek the following: a declaration of plaintiffs' charter rights under Section 7 and 15 are being violated. No, you have to plead those separately because maybe the court thinks that Section 7 is being violated, but not Section 15. So they can strike both of them by saying, I don't agree with you.
Yeah, because yeah.
You have to plead that separately. You have to have Section 7 and then Section 15. They're two different things. Mm-hmm. Okay. And then at the end, such further and other relief that is honorable court may decide is provided for under Section 24 sub 2. Not right. It's two times here. This is a glaring error. I don't know what's going on here. This is the kind of thing that gives me pause. It gives me serious pause. An otherwise well-written statement of claim and somehow not struck with which I believe was a motion to strike that was brought. Section 24 sub 2, it won't grant any remedies under the charter. It can only exclude evidence based on something that can bring the administration of justice into dispute. That case law is very, very ample. Okay, Section 24 sub 1 case law is very, very ample. You can't confuse the two. It even says under Section 24 sub, well, I'll read it to you. It says where in proceedings under subsection 1, a court concludes the evidence was obtained in a manner blah, blah, blah. So it even says Section 24 sub 1. You have to reference Section 24 sub 1. So I don't understand what's going on there, and that has to be amended immediately. 24 sub 2 has to be replaced with 24 sub 1. It just must be done right away. Because if you don't do that, you will not get a remedy under the charter. You won't. It's a fundamental error of law. It's an easy way out for the court to say I can't grant a remedy. And
like clumping 7 and 15 together.
Don't you got to plead Section 2A, 2A, 2D, 7, 15, all separately. They have to be pleaded separately.
Yeah.
You have to say that they're two different things. One says a declaration of the plaintiff's charter rights under whatever section have been violated by the corporation in a manner that is not justified in a free and democratic society. Basically saying it's not justified under Section 1. And the second thing is damages for violation of the plaintiff's rights pursuant to. And you have to name all of them separately. Section 2A, 2D. These should all be different lines. Section 7, Section 15. It all has to be. And maybe you can even argue Section 8 in terms of requiring people to provide their medical information under the charter under Section 8. Maybe that should be pleaded, right? And saying it's not proper to circumvent all the laws that we have, in terms of unreasonable search and seizure, whether it's the seizure of those medical records was reasonable or not. You probably lose on that. They'll probably say, well, it's COVID, whatever. You'll probably lose unless you have really good evidence, expert evidence to displace that, to say that there were other reasonable alternatives at the time. You need a bunch of experts, and I know a lot of experts. So anyway, but search and seizure, this is critical. Reasonable expectation of privacy. Okay, everyone has the right to be secure against unreasonable search and seizure. In my view, asking you for medical records is an unreasonable search and seizure. That's my view, and it hasn't been tested yet. This Section 8 is not being tested yet with respect to COVID. Maybe at this point, if you have good evidence, but can you amend it at this point since you brought the claim and it's way past the 2-year statute of limitations act? Can you do this? Can you bring the Section 2A and 2D? Can you bring Section 8? 2A and 2D, as I said, are absolutely critical. You have to bring them. I don't know how you can't. Section 8 is it's worth arguing. But 2A and 2D are not in there. If you cannot bring that in now, maybe you can't, but then you're going to go through another motion to strike, and that's going to cost a bunch of money. I don't know what'll happen. If you change all this stuff, I think it's worth doing. Definitely Section 2A and 2D. They said, the door is open from the court to amend the statement of claim. The door is open. So why not put in 2A and 2D and 8? The opposing, the Attorney General, or whatever, it's not the Attorney General, it's the Municipalities Council, the City Solicitors Council. They're going to cry foul. They're going to be very upset. Too bad. The judge left the door open to amend the statement of claim. So why not? Why not add, the charter is clearly brought up, put in Section 2A and 2D, put in Section 8, put in Section 24 sub 1, totally removed from any evidence that you ever tried that you put in Section 24 sub 2. That is just, I can't understand it. There is no, I can tell you, 100%. I'm not a lawyer. 100%. I can give you all the case law regarding Section 24 sub 1 and 24 sub 2. 24 sub 2 is really, there's 2 cases, Grant and Subaru, and there's a bunch of other ones, but that's from 2009. That really guarantees. Yeah.
Do you think it's possible that it's a simple clerical error?
Nope.
That he accidentally put number 2 instead of 1?
Professional negligence. This is really bad stuff. It's inexcusable. It's totally inexcusable. They may have good lawyers. The lawyer who drafted this stuff to begin with, and then they went to another, I don't know why they went to another law firm, but they went to another law firm. How the hell is it that 2 different lawyers missed this? It's plain as day. I mean, we're looking, you can go right back to Section 24. You can't claim a remedy under Section 24 sub 2 other than the exclusion of evidence. You can't. That's it. Like 24 sub 1, the case law for that is Ward v. Vancouver. Or sorry, it's the other way around. Vancouver v. Ward. That's from 2010. That case, there's an earlier case, Doucet Boudreau v. Nova Scotia from 2003. And there's other cases. There's Henry. That's another case. And there's a bunch of other cases as well. There's a lot of Section 24 sub 1 cases. Okay, in terms of violating your constitutional rights and paying out. The Henry case is an $8 million payout for the guy he was wrongfully convicted. They withheld all sorts of stuff, and he spent all sorts of time in jail. He got $8 million under Section 24 sub 1. Before that was the Vancouver v. Ward case. Guy was strip searched, all this stuff happened, and he was awarded $5,000. A lawyer, a black lawyer in Vancouver. And he took it all the way to Supreme Court and won. And they established that's worth, back in 2010, it was worth $5,000. Maybe it's worth $6-7 now with inflation. So anyway, those are the cases. I'm telling you, you can look up Vancouver v. Ward. You can just go into the Supreme Court and type in Ward. Type in Ward. Go there and look at it. Type in Henry, but definitely Ward in terms of Cannelly Read it for yourself. The Vancouver v. Ward is the number one case. They talk about, the Supreme Court talks about applying a Ward analysis in every case involving charter damages. You want money. It's for the interrelated functions of vindication, compensation, and deterrence. The interrelated functions. It's paragraph 25 of the decision. I know it very, very well. So the fact that that's not in here is a huge red flag. That's the kind of thing I would tear a strip off counsel for that. I'd say, what are you doing? I would say this is completely inexcusable. How the hell can you miss
they were sabotaged? You think they were sabotaged?
I'd have to hear the people and hear what's going on behind the scenes. I'd have to look at the arguments that were made. If there's a motion to strike made, there's a factum, written arguments that were made by the municipality. And then there's a responding factum made by the lawyers of the plaintiffs. And then there might be a reply factum, the final word from the municipality. And there will be a motion record for both sides. And then and anyway, at the very least, I need to know what was argued. And then we have to see, like, what are they going to do with the statement of claim? Are they going to bring in experts? Like, you have to bring in experts. There's a lot of stuff you have to do here to win this. You can't just argue it on a legal basis, because at the end of the day, if you throw this to court and the court says, I think it was reasonable to believe that everyone was scared to death of dying of COVID in 2021, February 14, 2022, when they invoked the Garbage Emergencies Act, froze everyone's bank accounts, and went after convoy participants. You're not going to win. You have to demonstrate that the evidentiary basis is a pile of garbage, that they knew or ought to have known. They knew or ought to have known that this stuff was not legal, and it was not justified under the evidence. The evidence, clearly they knew from the product monographs, or they should have known. Mm-hmm. That's what should be here. And it's not, this stuff isn't in the statement of claim. The statement of claim is well written, but there are things like that are not in there. And ultimately, you have to bring expert evidence. And yes, will the experts charge some money? They will. But you can get good evidence. You need several experts. I would say probably at least 3. Do it properly. Ask experts the right questions so you can win this challenge.
Yeah. Yep. I think the biggest elephant in the room is that they all worked at home, remotely.
That's what's so good about this. That's what's so good about it, because ultimately they're using provincial law. And, and if you look at the policy, the testing provision is illegal because under section 77.8 subsection 6, I mentioned this earlier, it's illegal. It says the chief medical officer of health may not compel someone to provide a bodily sample for substance. It's not legal. Okay. And not only that, there's some Personal Health Information and Protection Act. Section, I think it's 18. And what does it say there? It says section 4 has definitions. It talks about knowledgeable consent, not informed consent, knowledgeable consent. Section 18 talks about compelled production of a bodily substance. That's provincial law too. That's testing. That's not even, we're not talking about vaccination. Vaccination is section, I believe, 38 of the Health Protection and Promotion Act. Makes reference to the Healthcare Consent Act. I know this stuff like off, I've talked about this so much, not recently, but back in 2021, 2022, 2023. I know this stuff, and no one's bothered arguing it. Like, it's there in the law to protect you. Why not argue this stuff? Saying there's a conflict of law. It's a blatant. They broke the law. You have to follow the law. It would add to their arguments. Why not? But they haven't. So this stuff has to be in there. They have a door wide open here to amend the statement of claim. They can add a bunch of stuff in there. They can totally change the statement of claim. I don't know what the case law is regarding that, but they got to do something. There's not enough here. And as I said, the 24 sub 1, that's easily corrected. Adding in 2A and 2D, I think that's easily added there too. Putting in expert evidence later, I think you do have to give them notice that you intend to lead with expert evidence. But so put it in there. maybe Section 8 of the Charter, maybe stuff regarding the Health Protection and Promotion Act. They didn't mention it. Maybe you can, maybe you can't. But at the end of the day, Directive 6 was really, as far as if I look at this, if I just go backwards and look at this very quickly, I don't think Directive 6 is mentioned in this statement of claim at all. So, and they don't want to challenge something that's moot. I get it. They just want damages, right? So they're just saying they broke the law, and they could say that this Directive 6, it was never legal under the act that it was made under. They don't mention any of that stuff here. It was never legal. It completely violated its enabling statute, and the court should make a declaration, despite it being moot, for the purposes of this claim, that you should seek declaratory relief, that it violated, just like they're saying it violated the municipal act. Maybe they're afraid that's legitimate. They could be afraid that Directive 6 is long gone, and therefore, they'll just, you're giving them, the municipality, something to work with, to say that they're just pleading something that's a moot because this thing is long gone, and you're challenging in 2025, and it was in April of 2022 where it was rescinded. So it's like, this is way, 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 way past, and it's a total waste of the court's time. That's what they might be afraid of. But as I said, in there, it references the Healthcare Consent Act. At the very least, they should argue the Healthcare Consent Act. And I think maybe the original statement of claim mentions the Healthcare Consent Act. I don't have it in front of me. But the Healthcare Consent Act is very good to mention because it is provincial law. And then there's some, but anyway, the biggest problem is this, and sorry, I didn't mention this earlier, and I don't want to, I know we've been going on and on this, and I don't want to keep going on and on. But there's this horrible decision that was made in November of 2021, and it went to appeal, and the Court of Appeal agreed with this decision. It's a horrible decision. And it says here, let me see here. I just want to read you what it mentions here. Okay, so this is from, it's called the Amalgamated Transit Union Local 113 versus the Toronto Transit Commission. So it's a mouthful, but he went before one judge, the same judge who was in the Adam Skelly case at the first appearance, and I want to just read this to you because it's just a horrible decision. And this decision is used to crush a lot of challenges. Okay, this is especially union challenges. This is their favorite case. It's their number one case. This and the Now You case that's called the National Organized Workers Union case. That's the one that went to the Court of Appeal. These two challenges are used to crush every union challenge, especially in Ontario. So you have to be aware of these. So I'm going to read you just a few paragraphs so you understand what's going on here. It says, Now You argues, the National Organized Workers Union argues that the relief, this is paragraph 47, that argues that the relief sought in this application is necessary to preserve the employee's rights pending the completion of the grievance process. It argues that without the injunctive relief, at least some unvaccinated employees will be coerced into becoming vaccinated, contrary to principles of informed and voluntary consent. For them, the arbitration will become moot. As Justice Dunphy put it in Blake, which is a decision rendered the month before, that was the first vaccine mandate challenge in the country. It says no remedy exists to undo a vaccine once administered. Okay, then let's see here. The next paragraph, section 48. Paragraph 48. This raises squarely a consideration that also arises in the context of the analysis of the irreparable harm branch, of the test for interim injunctive relief. Now You argues that the vaccinated policy is coercive, and the employees who get vaccinated against their wishes will be irreparably harmed through violations of informed consent to medical treatment and bodily autonomy, and the reasonable probability of personal injury arising from the vaccine. In the context of the jurisdictional argument, this harm is alleged to render the arbitration moot if enforcement of the policy is not enjoined. I don't want to read the next one. Okay. This is the meat of this decision. This is the most horrible part. Okay, what I'm about to read you. It's paragraph 50. In my view, Now You has mischaracterized the harm at issue. The harm which the employees may suffer is being placed on unpaid leave or being terminated from employment if they remain unvaccinated. They are not being forced to get vaccinated. They are being forced to choose between getting vaccinated and continuing to have an income on one hand, or remaining unvaccinated and losing their income on the other. Characterizing the harm in this manner is consistent with the recent decision in the Superior Court of Quebec, which was not even reported at the time, which I've never even read, in paragraph 144, where the court concluded that a vaccine mandate did not cause irreparable harm because it did not force vaccination. And they then had the gall to quote this all in French, not even translated. So
manipulation.
So it says, and this is paragraph 52, because I've included the harm in this case is not the alleged violations of informed consent, bodily autonomy, with reasonable probability of personal injury from being coerced into being vaccinated. The expert evidence proposed by the parties with respect to the safety of vaccines is not relevant, and I need not address it, nor consider whether the experts ought to be qualified. No one is forced to get vaccinated. To be clear, I was intimately involved in this case behind the scenes. Dr. Byron Bridle submitted 127 pages of evidence, which was not refuted by the Sinai Health System, because they melded two different appeals together. They did not contest it. Not chief medical officer of health, the head of the science table, Dr. Peter Uni, came up with 9 pages and said, I disagree with this expert. I disagree with him. He didn't refute anything. Dr. Bridle had, over 200 footnotes, 127 pages of expert evidence. And the judge refused to even look at it. And then it went to the Court of Appeal, and 3 judges refused to look at it. They never even acknowledged its existence. So this is the problem. I'm furious. Believe me, even now, it's years later, and I'm furious. They refuse to look at the evidence. Aren't the courts supposed to be, they have a truth-seeking function to look at the evidence and challenge what is out there?
And who appoints these judges?
I know that judge was a liberal. Look, this is a big problem because I'm saying it's a big problem, not necessarily because of who appointed them, because in the Court of Appeal, on the Now You Appeal, 2 of the 3 judges were conservative appointees. 2 of the 3. The one who wrote the decision was former counsel for the CPSO. But the other 2, and she was a liberal appointee, Justin Trudeau. But the other ones were Harper appointees. So you can't say that. 3 judges refused to look at the evidence. They refuse, and an injunction. Injunction is not the charter. Injunction has a 3-leg test, a tripartite test. Whether it's a serious issue to be tried, whether it's irreparable harm, and whether in the balance of convenience it justifies granting it or not. There's no charter analysis. It's on the evidence. Injunctions are always based on the evidence. They said, well, it's beyond our jurisdiction because the labor relations regime has a jurisdiction. But you can't even get an injunction by a labor board or by an arbitrator. You can't even get that relief. Yet this is the law today in Ontario. So this is the kind of stuff that is terrifying. If you're in Ontario and you're someone who was union and you were fired, this is the kind of thing that I'd be terrified of, because the other side's going to keep arguing that. And the good thing is that they argued it, presumably. I don't know what was argued because I haven't seen it, but presumably they argued that it was beyond the jurisdiction of the court to hear it because it's a labor relations case. They're all union people, right? So it's labor relations, and it was not struck. This misfeasance of public office was struck, but nothing else was struck. The motion was otherwise denied. That's very good, and you can't go back to the well again. You can't revisit it. You can't relitigate it. That's the power in this case. This case is problematic in what I outlined, but at the same time, it's still alive. If you amend the statement of claim, this case, and you put in the saying you're going to bring some experts. You put in, 24 sub 1, 2A, 2D at the very least.
Yep.
And, this could be heard with experts. You can say they knew or ought to have known the vaccines didn't prevent transmission or contraction. And then maybe you win in 2025 or 2026. You win, 4 years later. I would say between 3 and 4 years after they won in New York. Maybe you win on that basis, that the vaccination was completely arbitrary and irrational. It made no sense whatsoever, given that these people were at home. We see the expert evidence. It can't prevent transmission or contraction. It's over. And so as a result, your Section 7 rights are violated. Your Section 2 rights are violated. 2D definitely, because they didn't go through any type of actual collective bargaining. They just imposed it. That stuff is powerful. Maybe you don't win on Section 15. Maybe you don't win if you do a Section 8. Maybe you don't win on that. But Section 7, fundamental principle of fundamental justice is informed consent and bodily autonomy. So I've said enough. It's gone on very long, as it always does, unfortunately, when I talk, and a lot of people joke about that. But this is a critical case.
No, it's good. Yeah. It's good because there is a lot of things have to be covered, and you didn't repeat it because of their importance. But hopefully everyone involved in this case will, watch this video, stop and start it, write all this down. I've sent the charter to Eli on X so he can look at all the charter. What can be done, and there is a way. I mean, it's not a guarantee, but these things were missed. These sections were missed, and they are important and fundamental to the
critical
case.
These have been successful. Section 2A, whether it was specifically argued or not, has been successful in the United States equivalent and in Canada. It's been successful across the board. It's gotten people a lot of money, Section 2A. I'm not saying it'll be successful here. I don't know what these people believe or don't believe. But if it's something that you can do, then do it. Section 2D, I've only seen it argued once in that class action in BC. I've seen it argued once, and the motion to strike was unsuccessful. The 2D survived the motion to strike. The next phase is certification. If that's certified, the argument there is that the unions didn't go through a collective bargaining process. They just imposed it, or the corporation imposed it. The union didn't bother doing anything. What they should have done is gone through a collective bargaining process, at the very least called a vote. And you know what? The reason why they didn't do this is because the vote would have failed. They would have failed. There would have been too many people. They said, if you look at what all the unions said, they said 99% of our members agreed with this garbage. 99% of them. In reality, even if it was 70 or 80%, you would see that a lot of people disagree with it, again, in the minority. But you would see like 15, 20, 25% of the membership strongly disagreed. And yes, it would pass, but they would show that these people are not isolated. The way that they sold this, and they said, you're the only person in this entire office. You're the only person who's refused to be vaccinated. You're the only person. You're a crazy person. You're horrible. You're the only one. And so you're like, it triggers that fight or flight response, which goes back thousands or even tens of thousands of years, that you're the only person. You're going to have to fend for yourself in the cold and die. So that's what it was a psychological operation. We all know that. But this is what they did. Absolutely. So that's why they didn't call a vote, because it would have showed a lot of people were against.
Yeah, and all the pre-organizing, this is 100% a conspiracy, which includes almost everyone, the media, the government, pharmaceutical industry, the courts, the unions, everybody. All right, Chris has left the building for temporarily, but all that information is available online. The Canada.ca. You can get the Charter of Freedoms and Rights right there on the website. And welcome back.
Yeah, I got booted there for a second, but anyway, everything is good.
Yeah, so as I was saying, it seemed like a very well thought out plan, almost like a 9/11 ish kind
Yeah,
of well thought out, and it was on a worldwide scale. It wasn't just Canada. So I mean, this was very well thought out, and all the
I
bases were
yeah,
covered.
I would still say that 9/11 was one thing, and that was, remember 9/11. 9/11 was like one event or three events or four events or whatever on one day, or five
Yeah,
events. You know, the bottom line,
yeah.
it was all on one day. And so then you can look
They
at
changed
later
priorities.
on and look at all the footage and everything else. And remember, back then it was very different from today. They didn't have blogs, and there was no YouTube, and there was video that I got off of CNN and all that. I got a lot of video back then, but there was a lot of stuff that
Hmm.
wasn't around back then that there is now. With respect to this COVID,
Yeah,
everything COVID related, people bought the psyop. It was totally different from 9/11 in that it was
yes,
like one day of horror. And
yeah.
with respect to COVID, the first part was the declaration of a pandemic on March 10th of 2020. Then there were the lockdowns in certain places. Then there was the
Yep.
declaration of emergencies in Ontario. Then the lockdown after that, right? I said if we go through the lockdowns, we're not.
Yeah.
It's going to be years or decades before we get back to normal. So that
Well,
it went
9/11
from
is like
there.
when they
Yeah,
9/11 is like when they broke the laws of physics and hard science and threw it out the window, and COVID was like throwing medical obvious. You're healthy, you got a cold. It's very easy to establish whether you're sick or not. But
yep,
it's, they like the spreading aspect to make everyone scared.
yep, yep,
They
for
just
sure.
love that. People are still in their cars with masks on, not realizing the harm
It's
they're doing to themselves.
there are people who still wear masks. Luckily, there aren't many of them. You'll see
Yeah,
them, but in a room full of people, maybe,
it's
and you'll
true.
see one person. So
Yeah.
thankfully, not many people are buying into this anymore, and they're really rethinking things. There are a lot of people have woken up. They're really
Yeah.
rethinking things. So I would say that I personally really want them to lock us down again. And I really want them to impose very harsh mandates against us again. It's the only way we'll win. And if people look, oh my God, but look what just happened with the election. And, Mark Carney's in, and we don't
Hmm.
have 50% of the population, we'll lose. And I'm like, I don't care about any of that. You don't understand how trends are made, how the law is made, how culture is formed. It's from the minority.
Hmm.
That's how the trans stuff got in. Do you think the trans stuff got in there because you got a majority of people agreeing with that stuff? No, it was a very
Nope.
small portion of the population, and eventually that 0.5% or 0.1% went to 1%, and eventually went to 3 or 4%, and maybe
Yeah.
5%, and then through
Yeah.
that they were able to influence. And we have the numbers to crush those people tomorrow, like literally on
Hmm.
Monday morning. We have the numbers to crush them. We have at least 10%. And in Canada, that's over 4 million people. We had 2 million people go through the convoy in over 3 weeks back in 2022. We have, I would say, at least 10 million people. There's nothing, sorry, 4 million, 10%, 4 million people. If we have 4 million people, there's no amount of government, of law enforcement, military that can do anything about 4 million people who completely are intransigent. They will not give in. And that's the only way to do it, because we have a government now which cheated its way into office. They cheated their
Yes.
way into getting uh, at least 10 seats. At the end of the day, the Liberals still have a minority government. I believe the Liberals legitimately have a minority government. I believe that the baby boomers legitimately voted for them and put them in office. And that's a huge problem. But
Hmm.
at the end of the day, if they impose these restrictions on us again, it's up to us to say, hell no, we're not doing it again. And if enough people do
Well, the
that,
thing
we
is,
can't enforce it.
I don't think they, I don't think they're going to do the same thing. Like
I
9/11 was
hope
one
not.
thing.
I mean,
That's
I mean,
one thing.
yeah,
I don't think they're going to
yeah,
stop.
yeah. They're not
I
going to
don't know what
stop.
they're going to do next. They're going to do something
But,
different.
well,
Who
they
knows
have
what?
limited tools in the toolbox, right? They
Yeah.
have We tried. We
Yeah,
saw what
no,
happened when they flipped over their toy trains. We saw what happened
yeah,
with cyber
yeah,
attack, like when in Canada, July 8th of 2022. I don't. Can you look at that as anything other than cyber polygon imposed in Canada
yeah,
across the
yep,
country with Rogers Communications? They said
yep,
they swore up and down it wasn't a cyber attack. It's quite a coincidence how many months, probably a whole year in advance, we knew that on July 8th of 2022, they're going to be doing this big simulation. Now, they didn't say they're doing it in Canada, but they said it's in Switzerland with the World Economic Forum and all that. But the point is, yeah. Yeah. So we want to wrap this up. If
yes.
anyone has any questions, by all means, ask. I can maybe see them here in the comments.
Um,
And
I
yeah,
I I don't see any questions. I think you actually touched on everything that is important. And again, I'm so grateful to you, Chris. Both times you came on here, like Kimberly Newdorf. I mean, I love that whole family. And the courage and the mama bear strength, and they all sing. I mean, I just love that whole family, and same with Eli here. He's also a very good friend. So I want to thank you for coming again and
thank you.
giving us your time, and you're showing people that you don't have to be a lawyer. All the documents are there. The legal documents are there. The laws are there. That you just have to read them, just like a book. Find your section, and the important part of this is he's pointing you right to the section, so you don't have to search and boggle your mind trying to find solutions.
And I
And that's what
listen.
it.
I would be very happy to go to Niagara region and talk to these people who are part of
Mm-hmm.
this and help them. And again, I'm just simply advising them to talk to their counsel. I'm not doing anything other than that. At the end of the day, counsel will agree or disagree. Counsel is trying the case. I have nothing to do with it. I'm someone
Yeah.
who's there to translate between legalese and this
Yep.
stuff, the statement of claim and
Yeah.
this apparent motion to strike. I'm there to translate between that and the plaintiffs. And so, yes, I would be very happy to help them and talk to them about it and literally go to Niagara because I have, for some reason, me and myself and Niagara, we go well together. When I talked to a lot of people in St. Catharines back in 2021, there were
Mm-hmm.
a lot of people who showed up. And then there's the Cullen McDonald case, also in Niagara.
Yep.
So I
Yep.
don't know what it is about Niagara. I mean, there's a lot of crazy people in the government there, yeah, but at the same time,
Yes.
in terms of the resistance in Niagara, really good people, and I get along very well with them. So if you want me to talk to you, reach out somehow through Paul. It's on Facebook. Reach out,
No,
and then maybe I can meet with
Eli's
them.
connected to you.
Yeah.
Eli is the one that sent you the email.
Okay. Perfect. So then we're
He's
in touch
connected to
already.
you
So
already,
right.
and
Right.
he's a couple of blocks from me. So if you do come down, I would love to see you again and
Yep.
make a day of it and chat. I
For
would
sure.
love that too. I'm sure Eli would like that. And thank you all at home for coming and hearing us out and hearing about a case that may have been a couple of years ago, but it still matters. And it's why I do this. Really, it's because I do care, and Chris cares, and Eli cares. On behalf of all of us, thank you for joining us, and we hope you have a great weekend. Hope you had a great weekend,
Yeah. We're at the end. Yeah.
and we'll see you again. And I'll see you again, Chris.
For sure.
When you're to Niagara, I look forward to that.
Yep.
Thank you all again. Episode 88 on the Truth Table. Have a great night.